Yeah, I don't understand that.
You don't understand a lot of things, and that's most evident in the way you keep using language and legal concepts that may have a place in a civil trial but have no real basis in criminal jurisprudence, where the rules, standards, and procedures are fundamentally different.
Okay, well,
Okay,
Mr.
we had just called 25 CR 250, State of Kansas versus Sidney Taylor Leslie, Jared Regier for the state. Miss Leslie appears in person and per se. Miss Leslie, is that you?
Yes, Your Honor.
Where's your attorney? Are you going to have an attorney represent you?
I am presenting myself.
You know you have the right to an attorney, to hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply, which I think you've already done, but you did not request an attorney, is that right?
I did not request an attorney. That is correct.
You want to proceed on your own behalf, and you can do that. No one's going to stop you from doing that. But is anyone making you give up your right to an attorney today by any threats or promises?
No.
And you understand you can hire, and if you can't afford, you can apply for court appointed. And if you qualify, one would be appointed. Do you understand that?
I comprehend, yes.
You do not wish to have an attorney.
I do not wish to have an attorney.
All right, I will show on the record that you've waived your right to an attorney and that you're going to proceed on your own behalf. So how do you plead then, Miss Taylor, or Miss Leslie, I guess it is. I'm sorry, I'm just saying it wrong. Miss Leslie, how do you plead to count one, interference with law enforcement officer?
A plead would be inappropriate at this time. I'm hoping to request a continuance.
Why would a plea be inappropriate at this time?
Okay, so Your Honor, for the record, I am Sidney Taylor Leslie in propria persona sui juris. I am here by special appearance only and not making a general appearance. I reserve all of my rights, remedies, and objections, including but not limited to any objection to jurisdiction over my person. I require a continuance in this matter. I intend on filing a subpoena for body cam and cruiser footage. There are facts in dispute on this matter that I'm looking to clear up before the matter can continue further.
You can request the body cam footage all you want, but you already posted the video yourself, and the facts speak for themselves. You refused to follow the officer's lawful commands, doubled down on your argument, and ultimately ended up facing the consequences in a moment that's hard to forget.
All right, I will grant a continuance for you to obtain discovery, but if you don't know how to do the things you just rattled off, you better have an attorney do it for you. Do you understand?
I understand.
All right, Mr. Aguirre, do you wish to be heard before I pick the date for this?
Your Honor, this does appear to be the first setting since the first appearance hearing before Judge Hart back in June. If the court is prepared to set this matter over for discovery purposes, the state does not object. I'm not sure if the court wishes to set that matter for merely control at this time, but I'll defer to the court on that point if the court will find that the bond is being continued and this continuance is at the request of the defense for speedy trial purposes.
All right, Miss Leslie, you're charged again with interference with law enforcement officers, a Class A non-person misdemeanor, driving without insurance, a Class B misdemeanor, and driving without a license in your possession, an unclassified misdemeanor, as well as failing to register your vehicle, another unclassified misdemeanor. The judge would have gone over these with you at first appearance. You want to go over them again as far as the penalties?
No, thank you.
All right. And you've indicated you want to exercise certain rights that you are entitled to and encouraged to. But as I said, an attorney could certainly help you carry out those rights. And you said you do not want that attorney?
That is correct.
Okay. Well, I'll have the record and the docket notes show that you have waived your right to counsel and that you know what you're doing. Now, then, do you want to set it for trial, Miss Leslie, or do you want to get the records and look at them and then set it for trial?
I would like to have a continuance, perhaps for discovery or an evidentiary hearing if possible.
Well, I can continue it for both those readings.
Okay.
For both those readings. to give you time to get all your discovery, the dash cam, body cam things you were mentioning.
Okay.
And then we can also set it for trial. So when's a good trial, 1:30 trial date, Jim?
Your next one will be September 24th.
All right, you'll need to be back here with all your witnesses, September 24th, 2025 at 1:30, and that will be by Zoom again.
Your Honor, if I may just get a little more time due to the fact that I'm going to be submitting the subpoena and I'll need discovery, and I need to just review it so that I can have adequate time to present myself for my defense.
Well, that's 30 days. You don't think that'll be enough? How much time are you asking for?
I'm hoping for at least 60 days.
Jen, do we have 60 days?
We have October 22nd or October 29th at 1:30.
Which of those do you prefer?
I would prefer October 29th.
October 29th. This is continued to October 29th at the defendant's request. Is that over your objection or not, Mr. Ricky? I don't remember any objections.
Your Honor, if the court is prepared to set this matter for trial, the state does not oppose that, but the state will be requesting a ruling as to whether or not the bond is to be continued and if this continuance is at the request of the defense.
Court does find this request at the defendant's, and the time will count against the defendant for speedy trial purposes. The matter is continued for bench trial to be heard and to be commenced August 22nd, 2029 at 1:30 p.m. via Zoom. So Miss Leslie, it's going to be here by Zoom. Right, be sure you have your evidence ready. If you're going to screen share it, whatever you're going to do, make sure you can do that. And if you need any help getting your discovery or presenting your evidence, you're always able to hire an attorney. And if you can't afford one, apply, but do it well in advance of the trial so that you can get the application completed, returned, and the court can appoint your attorney, and you and the attorney can have time to present your case.
Okay, yes, Your Honor, I did hear you say October 22nd. Was it the 29th that I had requested at 1:30?
You did, so I'll make it October 29th. Jen, you said
Thank
either. You said either, and she picked the 29th, correct?
That is correct, Your Honor.
It'll be October 29th at 1:30. Now, Mr. Regier will be subpoenaing witnesses himself for the state. And if you find out or decide you don't want to go with a bench trial, let him know as soon as you can so he can cancel any of those witnesses that he may have coming in.
Thank you, Your
Okay.
Honor.
You're welcome. And don't forget, you can look at diversion and see if that's an office option. You can call the county attorney, but definitely look into that issue of an attorney.
Okay, thank you, Your Honor.
You're welcome. Anything further from the state, Mr. Regier?
Your Honor, if the court is continuing the bond in this matter, I have nothing further at this time.
I am continuing the bond, all existing conditions plus the new ones I've stated on the record today.
Thank you, Your
And
Honor.
you're welcome, and Miss Leslie is excused at this time.
Thank you, Your Honor.
It looks like this young Karen has a court date coming up, although we may not get to see it since Kansas hearings like this aren't typically live streamed. I'll keep an eye on the case and, if there's a resolution, I'll bring you an update in a future video. But for now, let's head over to my home state of Texas and revisit another case I've been following, this time involving a sovereign citizen named Jose Elizondo.
We have defendant Jose Elizondo.
Yes,
Mr. Elizondo, you have a motion that was filed, so we will get to that after I take everyone's announcements. I just want to let you know that I do have you here, and I see that you're here, but I'm gonna take the announcements first, then we'll get that heard. All right, so if you can just stay logged in, we'll get you processed through promptly, all right?
all right.
Okay, thank you. All right, Mr. Bishop, we have two defendants with motions, and then we have one defendant set for trial. All right. So the first case set for motion is Jose Elizondo. Mr. Elizondo, if you can please unmute and show your video.
I'm here.
Okay, thank you. So, Mr. Elizondo, you had a pretrial hearing earlier this year in May, and then and at that hearing, you had indicated that you had mailed in a motion for a bond, and that was the only motion that you had, and we did not have that here. After the court, and we set your case for a jury trial on August 28th. Then after the date of your pretrial hearing, we received a motion in the mail stating defendant's Rule 91 motion to dismiss for failure to state a claim upon which relief can be granted. Mr. Bishop, have you received a copy of that motion?
Your Honor, and made a response.
Thank you.
I believe he's filed two motions. I've got a motion to dismiss and then a motion, no consent given motion.
Come to think of it, I can't remember a single case where a defendant had to personally consent before the state could prosecute them. But Jose seems determined to argue otherwise, so let me save him the trouble. Your consent is not required for the state to bring charges or prosecute a case.
Yes, that's correct. All right. So, Mr. Elizondo, if you wish to summarize your argument, you may do so at this time.
Yeah, I just want to know, do y'all enforce the Texas Transportation Code?
No, sir, we're not answering questions. You need to summarize your motion at this time.
All right, well, I just want to add to my motion that according to the Texas Transportation Code, Title I, Section 502.003 clearly states it prohibits political subdivisions from requiring registration, and my violation was due to registration. So that's all I wanted to add, and I plead not guilty and for dismissal too.
Mr. Bishop, your response?
Yes, I addressed this in my response, Your Honor. The city of Dalworthington Gardens is the political subdivision of the state of Texas. And this registration requirement is not a violation of a city ordinance. There is no city ordinance that requires individuals to register their vehicles. That's state law. And so the defendant is incorrect in applying that statute because it's a state law violation, not a city ordinance violation.
The court has read the defendant's motion to dismiss, and I have read the state's response to that. And the court is denying the defendant's motion to dismiss. I don't see where you prepared an order for me to sign. Let me see.
I did not prepare one, Your Honor, but I will be glad to prepare one.
Okay, if you can prepare one, Mr. Bishop, I will get that signed. I'm writing a notation here. Motion denied. Right. And then we have the second motion, defendants, no consent given. Mr. Elizondo, you may summarize your argument at this time.
Whatever I submitted is what I plead to continue with.
Mr. Bishop, would you summarize the state's response?
Yes, the state's response is in the state of Texas, driving is a privilege, not a right. And by exercising his privilege to drive on a Texas highway or street, he is subject to all rules of the road, statutes and rules. And so the state does not need his consent for him to be subjected to jurisdiction when he has violated a state law. He's not being denied his rights. Driving is a privilege, and by driving, he subjects himself to the rules of the road and other state laws regarding driving.
Like I said, your consent isn't necessary. Once you choose to drive a vehicle on public roads, you're subject to the laws and jurisdiction that govern those roads. You can call it whatever you want, but putting your car on a public roadway doesn't create a special exemption from the rules.
All right, based upon the court has reviewed the written motion and response, motion by the defense, response by the state, has considered the arguments made here in court, and the court is denying the defense statement of no consent given to jurisdiction. Okay, so Mr. Elizondo, your case is set for jury trial on Thursday, August 28th at 8:30 in the morning. That is when you need to be here. You have cited in some of your motions civil rules of procedure. As I have warned you before, I'm warning you again, the Texas rules of criminal procedure apply in this case. This is a criminal charge, and you need to follow the Texas rules of criminal procedure. You will be expected to follow proper courtroom decorum, and as you are representing yourself, you will be held to the same standard as if you were an attorney. You will need to be here at 8:30 in the morning. You will receive information regarding the venirmen, the potential jurors, and voir dire will start at 9 a.m. You will be given 15 minutes to ask relevant questions of the venire panel. The state will be given 15 minutes to ask questions of the venire panel. Each side is given the opportunity to make up to 3 strikes, and then we will proceed to the jury trial that day. Have any witnesses that you wish to call and any evidence that you wish to present here and ready when you get here at 8:30 in the morning. Do you understand, sir?
Yeah.
Okay. All right. Mr. Elizondo, is there anything else that you wish to put on the record at this time?
No.
Mr. Bishop, anything from the state?
Nothing further from the state, Your Honor.
Okay, Mr. Elizondo, you are released at this time. We'll see you here in person at 8:30 in the morning on August 28th.
Sounds good.
You are released at this time.
All right, that brings this hearing to a close. I'm not sure yet how accessible this trial will be, since I don't know whether Tarrant County makes in-person trials available online. Luckily, I do know someone who lives in the area. Me. So I'll see what I can do about getting a camera into the courtroom for what we like to call journalistic purposes. But for now, it's time to move on to the final hearing of the day, which, in a rather bizarre coincidence, took place in this exact same courtroom immediately after Jose Elizondo's rather unforgettable crayon-consuming episode.
Vincent Haynes, are you there? Please unmute.
Yes,
Okay. Mr. Haynes, are you able to share your video?
I'm working. I'm trying to.
Okay. I know all the controls are a little different. While you're doing that, I'm just going to go through the preliminaries. There we go, sir. So I show you that you have 2 cases pending. We have a expired registration and failure to maintain financial responsibility. And you sent in a motion to dismiss. And you also came in, that motion to dismiss came in on the 5th, and then you came in today and put down a cash bond of $21 towards the expired registration charge. So sir, I want to ask you, did you hear my explanation about defendant's rights and options that I went over at the start of court?
Yeah, I grant the court's permission to use my name.
Okay, sir,
on
I asked you a question.
return of equity.
Did you hear, sir, did you hear the rights and options that I went over at the start of court?
I'm granting the court's permission to use my name for future return on my equity. And you asked me if I heard what?
I'm asking you, did you hear my explanation about defendant's rights and options that I went over at the start of court?
I heard, yes.
Do you have any questions about those rights or options?
Not about those, no.
Well, what question do you have, sir?
I sent in and it was registered that you received an abatement. And my question basically before I submit any plea of any type is the jurisdiction, the subject matter jurisdiction. And in my motion to dismiss, it kind of covers all of that.
All right. Well, sir, this is a statutorily created municipal court, and I do have jurisdiction over Class C offenses alleged to have occurred within the jurisdiction of the city, the extraterritorial jurisdiction, and within Tarrant County. And you do have a motion to dismiss. We can have that heard tonight. with Mr. Bishop with his response, and then we'll proceed from there.
You can file motion after motion to dismiss, but none of it is going to matter when the arguments behind those motions have no basis in reality. The alleged offenses occurred squarely within this court's jurisdiction, and there's really no mystery about that. And if you're sitting in front of the judge to answer for those alleged crimes, that also establishes the court's authority over you. In other words, you can keep challenging jurisdiction all you want, but simply repeating the argument doesn't make it legally valid, and the judge is clearly not going to entertain a claim that has no foundation in law.
Mr. Bishop, we have the defendant Vincent Louis Haynes. He's facing 2 charges, expired registration and failure to maintain financial responsibility. And in July, he filed a notice of abatement. And a motion to dismiss. Mr. Haynes, can you please, there you are, Mr. Haynes, there, unmuted. All right. So, Mr. Haynes, do you wish to summarize your motions at this time?
Yes.
Go ahead, sir.
In my notice of abatement, I'm asking for the court to show that it can uphold the Constitution in reference to Article 6. I am basically stating that I am a natural person. You know, I'm in the court even currently right now with my Lord and Savior Jesus Christ, and the notice of abatement just goes to the heart of the matter as to the jurisdiction, both subject matter and personal jurisdiction, and to make sure that these proceedings are done to assure equity and fairness. I realize that this court may not provide a remedy for me, and so at that point, I'm asking for adjunctive relief if that would be appropriate.
Mr. Haynes, you're using terms that are civil terms. This is a criminal court. These are Class C criminal charges, which carry a fine as their punishment. This is not a court that gives a remedy to a defendant. You are charged with a citation. You are charged with a crime based on the actions of a police officer.
Who did I
And so, no,
offend?
sir, hang on. I'm not done.
Okay.
So I want to make sure you understand, you're using civil terms. The rules that apply in this court are the Texas rules of criminal procedure. And those are the rules that dictate how the hearings and trials will proceed. And it is the Texas laws which grant this court jurisdiction in these matters. I'll make sure you understand that. If you wish to continue to summarize anything, you may, but I want to make sure you understand you're using civil terms. This is a criminal court.
Okay. Even in a criminal matter, ma'am, I still have a right to face my accuser. Again, that's what the abatement was about. And who accuses?
Sir, hang on a second. You haven't gotten to that point yet, because this is a first setting, and if you plead not guilty, there will be a trial. But as you've seen here tonight, many people plead no contest or are guilty. Therefore, there is an opportunity to hear and have all the accusations presented in court. You just have not gotten there yet.
Yeah, I don't understand.
You don't understand a lot of things, and that's most evident in the way you keep using language and legal concepts that may have a place in a civil trial but have no real basis in criminal jurisprudence, where the rules, standards, and procedures are fundamentally different.
Okay, well, Mr. Bishop, does the state have any response to the abatement motion?
Yes, and I'm just seeing this motion for the first time tonight, but it appears he says that the court lacks subject matter jurisdiction over this ticket, and therefore the action should be abated. And I'm summarizing that. The state's response would be that this court has jurisdiction to hear citations for traffic violations and Class C misdemeanors in the city of Dalworthington Gardens. And so it appears these tickets were all alleged to have occurred in Dalworthington Gardens, and therefore we respectfully request that the defendant's motion be denied.
Your motion for abatement or notice of abatement,
It's a notice.
your notice of abatement is filed, sir, but there's no action that this court is going to take at this time. And you have filed a motion to dismiss. Before we go into that, sir, there's a couple of things that I want to make sure to put on the record. You've been here in the Zoom courtroom tonight. At the start of court, I went over rights and options that defendants have. Did you hear those rights and options, sir?
I heard the rights and options that's pertaining to those particular defendants, yes.
Yeah, that was to every defendant set here tonight. Do you have any questions about those rights and options?
I mean, I don't understand them pertaining to me.
Well, they pertain to you because you have received a citation and you're charged with this offense. You may not agree with it and you may not like it, but they apply to you because you were in the city of Dalworthington Gardens and received these citations. So that's how they apply to you. Now, as I warned everyone at the start of court, you have the right to be represented by an attorney. And if you wish to have time to consult with an attorney, please let me know and I will give you a pass until next month's docket. Otherwise, if you do not have an attorney hired to represent you, you will be held to the same standard as if you were an attorney. So at this time, sir, do you wish to represent yourself or do you wish to have a continuance to consult with an attorney?
I'll represent myself.
Okay, all right. All right. And if you do not have any other questions about the rights or options that I went over at this time, we can proceed now to the motion to dismiss. If you wish to present that at this time, you may summarize your argument for the court at this time.
The motion to dismiss comes from the fact that I put a notice of abatement in, and I never got a response from my notice of abatement. Just basically asking the court, for its jurisdiction. You're explaining how your jurisdiction kicks in, but it's not relating to what I'm saying. I don't go by misnomers, and I seek, the honorable court to apply fairness, and equity. This court does not state whether or not this is a court of equity. You're telling me right now that this is a criminal court. You're saying that this is a criminal case, and you're not really presenting a crime that I see that would be tantamount to criminal proceedings. But again, everything is laid out in a motion to dismiss, and I feel that it is warranted because the court does lack subject matter and personal jurisdiction.
Again, subject matter jurisdiction is established by the alleged facts underlying the criminal violation, while personal jurisdiction is established by your presence before the court today. It really isn't that complicated, but somehow you're still struggling to understand the basic distinction between the two.
In this hearing.
Response from the state, Mr. Bishop?
Motion to dismiss should be overruled, Your Honor, or denied. State has jurisdiction here. This individual was using the roads or highways of the state of Texas. And by doing so, as is driving being a privilege, not a right, was bound by the laws of the state of Texas when driving. The allegation is he has violated those laws, and so this court would certainly have jurisdiction to hear those citations. I believe there are two of them. One is registration. The other one is failure to maintain financial responsibility.
Court has reviewed the written motion to dismiss, has heard the summary from the defendant, Mr. Haynes, response from
I object, Your Honor.
I'm sorry, sir, what did you say?
I said I object.
To what, sir?
Because there's no city, state, or government that should make a rule or law that abridges my right to the freedoms and the privileges of the continent or the land of the United States. I'm a natural born man,
Okay,
and
that objection, sir,
I have
that
a
objection, sir,
constitutional right to be.
sir, you need, sir, I've heard the objection. Your objection is overruled. All right, your motion to dismiss is denied at this time. The allegation in the citation which you signed states that you committed 2 violations on in a location that is within the territorial limits of the city of Dalworthing Gardens.
Do you have the actual ticket?
Sir, you need to be quiet and listen. Within Tarrant County, within the state of Texas, that establishes subject matter jurisdiction for this court to hear this matter. The court has not made any ruling in regards to guilt or innocence at this time. However, that does give the court authority to hear this case. Therefore, your motion to dismiss is denied at this time.
Do
Now,
you have
sir,
the actual ticket, ma'am, that I mailed back in?
I don't know if you mailed it back in or not, but I have the copy that you received notice at the time and that you signed it. And that is all that is required.
I signed it under duress as well.
All right, sir, are you ready to proceed to trial tonight on your cases?
Proceed to trial tonight?
Yes, sir. This is the contest docket. You've indicated you wish to represent yourself, and you are facing the 2 charges of expired registration.
I need
and
to have
failure
a
to
trial by
maintain-
jury, ma'am. It's still, everything
Yeah,
is
well,
before.
we're going to get to there. So to the charge of expired registration, how do you wish to plead, sir? Guilty, no contest, or not guilty?
I'll make no plea, ma'am. I'm not pleading. I do not accept your jurisdiction.
Well, that's the step to getting set for a jury trial, is if you're going to plead not guilty. Are you pleading not guilty and requesting a jury trial?
There's no plea that I'm making.
Therefore, the court will enter a plea of not guilty for you. And you've indicated you wish to have a jury trial. Is that correct, sir?
The jury trial, yes.
Okay, so enter a plea of not guilty, setting you for a jury trial. So we're going to set you for a pretrial docket. And that will be September 3rd at 7 p.m. You will get a written pretrial order. You need to read it over. It explains what you need to do and the timing. If you have any motions that you want the court to hear as far as discovery or anything of that matter, they needs to be filed at least 14 days before the court, before the pretrial hearing. If you have any evidence you wish to be able to present to the jury, you need to have that marked and filed with the court according to the pretrial order. Once we have the hearing on September 3rd, you will be scheduled for a jury trial, which we have during the day. So make sure that when you come on September 3rd, you're aware of your schedule and any conflicts that you might have for September and October. You will get a written pretrial order and you'll get a reset notice. We'll see you back here on September 3rd at 7 p.m. You are released at this time unless you have any question regarding the scheduling, sir.
You say back here, this is going to be on a Zoom call again?
Yes, the pretrial will be on a Zoom call. Yes.
Okay, and I'll have instructions relating to all of this as well.
You'll get it all in writing. It'll be signed by me and you should receive it early next week, if not earlier.
All right.
Okay. Just watch your email, check your spam folder because there will be some attachments, so they might go to spam or junk if you have that. All right.
If I have any questions, I'll make sure I call your clerk.
Call, or you can send them in writing, either way. All right.
All right.
Okay. This concludes your hearing. You're released at this time. We'll see you back for your pretrial hearing September